I am Daniel L. Five, a resident of Seattle, Washington, United States. This is an open letter to Governor Inslee, Governor Jay Inslee, and the Democratic leadership of the state of Washington concerning the lack of leadership in addressing bank fraud legislation in the state of Washington. Leadership, I come to you with impeccable Democratic credentials. While too young to vote for Kennedy in 1960, I was on the streets supporting him. I have been involved in a Democratic campaign almost every year since 1968. As a precinct committee officer in the 32nd, 37th, and 34th districts, I have helped elect Democrats to the House and Senate. As a board member and former vice president of the Seattle's Metropolitan Democratic Club, I have furthered the issues of the progressive ideas of the Democratic Party. Now I come to you with the most serious issue facing our state and nation, and I ask for your action. As we are all aware, the largest fraud committed in the history of the United States started with the repeal of the Glass-Steagall Act in 1998 under President Clinton. This fraud was exacerbated in 2001 when the major banks joined together to securitize loans without the borrower's permission or giving the borrowers legal and rightful commission. The fraud was exposed to the country in 2007 and 2008 when bank failures produced the greatest recession since the Great Depression of 1929, also caused by the banks, some of them the same ones, in particular, in my case, JP Chase. This bank fraud came home to me on September 25th, 2008, when Washington Mutual Bank failed and my loan was purchased by JP Chase for 6 cents on the dollar, about $30,000 for my home. Since then, Washington State Legislature has not passed one piece of constructive legislation to deal with the problem. The foreclosure, I call it the Unfairness Act, is a total farce. Every attorney one talks to states that the FFA, the Foreclosure Fairness Act, is just one speed bump away from the foreclosure process. The Deed of Trust Act allows banks to foreclose without proof of ownership. I and countless others have come to the legislature over the last 6 years to try to get the laws changed to recognize some legal fairness. We have all sat quietly in front of the hearings while lobbyists and the banks have persuaded the legislative committees of how fair and honest they are. Just last month, I attended a House hearing where only 3 of the legislators were present. For my effort, spending nearly a day coming down from Seattle, I received 2 minutes' time. The lobbyist received a private hearing. I next attended the Senate hearing where no private citizen was allowed to speak. Only the lobbyists for the banks and the people from the Department of Commerce told how wonderful that the FFA legislation was producing results. Any casual observation shows the total disaster of this legislation. As a person who has participated twice in mediation, I can testify personally to the incompetence of the department and the corruption of the mediators. On January 28th, several of us traveled to Olympia to speak before the House Judiciary Committee. When the bill came up for consideration, it had been changed from its original wording, and after the lobbyists for the bank spoke, the meeting was canceled. With some small measure of apology, we were notified that we might have an opportunity to speak on the conference call for 2 minutes, 2 minutes each on February 2nd. On February 2nd, I again returned with many others to hold a rally on the homelessness between the Senate and House buildings. A woman, Karen Poley, and I went to see if we could talk to the representative head of the Judiciary Committee. Though we were only asking questions, a house guard was called and we were escorted into the hall for causing a, quote, disturbance, end quote. We then went to Representative Orwell's office. When Karen mentioned to her aide that Representative Orwell had told the aide last summer that, quote, she was sick and tired of the Deed of Trust Act, end quote, the same house guard, accompanied by an armed Washington State patrolman, again escorted us into the hallway. Neither of us created the, quote, disturbance, end quote, of which we were accused. But we both agreed that we were also sick and tired of the DTA as written. Later, we all gathered at the plaque between the buildings to demonstrate our dissatisfaction with the progress of legislation. The group numbered well under 50 people and was composed of well-dressed people over 50 years old, some with their walkers and one in a wheelchair. Within minutes, 5 armed Washington State Patrol surrounded the meeting. When I asked one of the patrolmen why they were there, he pointed to the House of Representatives building and stated that a legislator had said there was a disturbance. When I asked him if he could see a disturbance, he declined comment. This outrageous behavior by our Democratic state legislatures is unacceptable. That afternoon, we were allowed to call in. To start with, the head representative of the Justice Committee admonished us for the disturbance that did not happen. We were allowed to speak out for 2 minutes, but with only that representative and Representative Orwell on the phone. I doubt that the other 11 representatives listened to our points of view. This behavior is totally unacceptable by our elected officials, particularly Democrats. In all my years of a political activism, I have never been treated with such disdain. There are now 4 Washington State Supreme Court decisions clearly outlining the severe deficiencies in the laws concerning the banking industry and the foreclosure process. Countless lawsuits at great expense and personal suffering have also concluded that the deficiencies in the present law. It is the responsibility of our legislature and our governor to correct these egregious failures this year. More micromanaging the legislation in favor of the banks is totally unacceptable, particularly for Democrats who purport to be the People's Party. Therefore, I am asking the following. 1, Governor Inslee, that you place the executive order stopping all foreclosures until proper and decent legislation is passed. Governor Inslee, that if the legislature will not act during their normal course this session, call a special session and make them deal with the problem. House Speaker Frank Chopp, Majority Leader Gail Tarleton, Senate Minority Leader Sharon Nelson, introduce legislation that will correct the deficiencies. 4, if need be, change the leadership of the House Judiciary Committee. I also suggest the following legislation. 1, eliminate the Foreclosure Fairness Act altogether. 2, change the Deed of Trust Act from a non-judicial foreclosure state to a judicial foreclosure state. 3, insist that before any proceedings start by a bank, they prove the actual note holder. 4, insist that any money that the bank has received outside of the borrower's obligation to pay be deducted from the amount owing, as they have already received payment. This must include monies received from securitization, insurance payments, and any other monies received legal or illegal. In my case, this would include the tremendous discount that JP Morgan received for taking over my loan. In conclusion, It is years past time that the Democratic House and Senate represent the citizens of the state of Washington, not the banks, their lawyers, and their lobbyists. Being surrounded by armed state troopers reminded me of the civil rights movement of the 1960s, where that at each time people stood up for their rights, for the rights of the blacks, they were surrounded by public officials and often beaten and killed. How many lives must be destroyed here in the state of Washington before our elected officials will stand up and do the right thing? Thank you for your consideration. I sign off, Daniel Five.